Mass deportations. Everyone wants them, the country needs them, and the two major parties on the British right are promising them. But who is more credible to actually deliver them? Is it Reform UK or Restore Britain? Well, we'll go through their comprehensive policy prospectus as well as addressing some of the additional policies that either party might choose to adopt, and whether the personnel of each respective party has any credibility on the issue, and if voters should trust them to carry them out. Yesterday, on the 23rd of February, Reform's Shadow Home Secretary Zia Yusuf delivered a press conference down at Dover and also released a snazzy video on X outlining what Reform UK's new mass deportation policy is. He announced that a Reform government will introduce a UK deportation command, mobilising more charter flights to try to remove what he promises to be every single illegal immigrant currently in the country. He also says that he will introduce an Illegal Migration and Mass Deportation Act to make it mandatory for Home Secretaries to deport every illegal immigrant. They will leave the European Convention on Human Rights and replace it with a British Bill of Rights, details of which are still forthcoming, and that if you come to the country illegally, via a small boat on the back of a lorry, you will be automatically denied your asylum claim. He also promises a new data fusion centre to harmonise data across government departments, which so far have been recalcitrant to produce data on how much money is being spent on illegal immigrants, or how many are even in the country, presumably powered by either Oracle or Palantir, who are vying currently for the software contracts for these government departments. Yusuf also promises to expand detention capacity to house 24,000 illegals at a time, processing them and putting them on flights to achieve a deportation rate of about 288,000 people every year, with presumably more voluntary deportations forthcoming. They're going to use a mixture of charter flights and RAF planes in order to do this, and Yusuf promises that this deportation bill has been costed to save the taxpayer £7 billion within the first parliamentary term. But there are still some questions outstanding from yesterday's press conference, and some things that Yusuf said at yesterday's press conference that weren't mentioned in the video. For example, will those who entered Britain legally but overstayed their visas also be automatically denied an asylum claim? I have heard before that both Nigel Farage and Zia Yusuf are interested in preventing the likes of students and visitors from attempting to claim asylum. Will this be included, an automatic asylum ban on visa overstayers in the Illegal Migration and Mass Deportations Bill? Also, they mention that there will be visa bans for countries that refuse to take back their foreign nationals, but will this only be if they refuse to take back their foreign nationals, rather than outright visa bans on the worst offenders? They also said they're going to end indefinite leave to remain, but they're going to replace it with a renewable work visa. This is something that has gotten the Trump administration in trouble. And why are we even continuing to have large-scale work visa programs for immigrants in the first place? If more migration was the solution to our problems, we wouldn't have any problems by now. Yusuf also said a reform government will terminate welfare payments to foreign nationals. Okay, but what about those born overseas with naturalised British citizenships who are here in the millions and also claiming benefits? Because I don't think a single person should be able to come to our country and become a net cost to the taxpayer. If you enter our country, you should be able to pay your own way. Will the benefits ban apply to foreign-born persons or just non-nationals? This is a very important point, as we'll talk about when we get onto the removal of indefinite leave to remain and why it might not stop the Boris wave later. Yusuf also announced that he's going to automatically afford churches protected status to prevent them from being converted into mosques, which is a policy that I support, and promises, if elected Home Secretary as part of a reform government, to prescribe the Iranian Revolutionary Guard Corps and the Muslim Brotherhood as terrorist organisations, and to also disband and rebuild Prevent from the ground up with a new body focusing on Islamic terror, which is something that I, of course, support. I've done a lot of reporting on the ideological capture of the Home Office by the Islamic Network, but there's not much talk of the Islamic Network, there's not much talk of the civil servants who will do their best to frustrate this agenda by Yusuf, and Reform haven't explained how they plan to disband those ideological activist networks in the civil service, because so far their plan to reform the civil service will not allow them to hire and fire civil servants who purposefully try to frustrate their agenda. We'll discuss this policy later. But the most concerning part of Yusuf's press conference was the announcement that the health and social care visa will stay. Yusuf said there will be a special temporary worker program to aid adjustment for low-paid workers in national critical industries such as care. This is one of the most abused visa routes in the country and was only introduced after Brexit, and is one of the main pathways for not just third world low-paid migrants who enter the system and immediately drop out and go on welfare, but also bringing large volumes of net dependents, far more than the actual workers using the visas themselves. As you can see here in the 2024 Migration Advisory Committee's report, health and social care worker visas made up the bulk of skilled worker visas from 2021 to 2024. This dropped recently because they cut the ability for health and social care workers to bring dependents, but these people will remain here, and all of them, mind you, are net tax recipients, because they're all paid via the taxpayer on the NHS. Both they and their dependents make up the bulk of the 95% of Boris Wave migrants who take out more in taxes than they contribute ever since Brexit. As Carl Williams points out in this article in The Telegraph, health and social care visas saw 647,000 migrants coming to Britain between January 2021 and June 2024. 270,000 workers and 377,000 of their dependents. He notes there's a 1.4 dependents per worker rate, which doesn't sound so bad on the face of it, but when you break it down by nationality, Nigerians are bringing 2-to-1 ratio of dependents to workers, Ghanaians a 4-to-1 ratio, and Zimbabweans, Rhodesia, a 10-to-1 ratio of dependents to workers. He also notes that in 2022 there was a 606% increase in the number of modern slavery cases in the care sector, with more than 700 potential victims. And in February 2024, it was revealed that a single testing centre in Ibadan, Nigeria, had provided 719 people, 1.7% of all Nigerians then on the health and social care visa, with fraudulent qualifications. They all ended up as NHS nurses and midwives. The BBC conducted an investigation into this, and this is happening across India and Africa and Pakistan, third world countries that have seen the disproportionate share of visas distributed to their nationals since Brexit as part of the Boris wave, and who do not share the prescription against dishonesty to advantage oneself, one's family, one's clan, and the Ummah. And Reform UK aren't against sourcing their legal migrants from these low-trust, high-crime epicentres in the third world, because if you read beyond the headlines that were put out around the time of Yusuf's announcement, you'll see that Reform's visa bans on countries like Pakistan are not permanent. They are not punishments for the ways that their expats have behaved. Instead, they are leverage to encourage those countries to take their illegal immigrants and foreign criminals back, meaning that when they start taking them back, those visa bans will be lifted, and we will continue to get legal migrants from Pakistan, Afghanistan, Sudan, and Eritrea again. As it says in this Telegraph article, Zia Yusuf plans to impose blanket visa bans on diplomats, VIPs, workers, students, and tourists from Pakistan, Somalia, Eritrea, Syria, Afghanistan, and Sudan. Pakistan is one of the largest sources for the UK's visas, accounting for more than 160,000 in the past year, but it only takes back 7% of its failed asylum seekers, and it is the leading offending nation for visa overstayers, for illegal migrants. I can't think of a single legal migrant from Afghanistan, Somalia, Pakistan, Eritrea, or Sudan, or Syria who would be worth taking in exchange for any of the Pakistani rape gangs. I don't think we need a single legal migrant from any of those countries, and so we shouldn't be allowing any more in. Instead, we should be encouraging or ensuring that millions of them leave. He also says he plans to renegotiate the UK's Brexit deal with the EU to enable the party, if it forms a government, to ban foreign nationals, including EU citizens with settled status, from claiming welfare benefits. Okay, but what about naturalised immigrants who then go on to claim welfare benefits after receiving their British passport. They still impose a cost on the taxpayer that never needed to be here in the first place. So why not just ban all people born abroad from claiming benefits? You chose to come here, you should support yourself, or you should leave. We shouldn't be expected to subsidise your stay when we never wanted to bring you here in the first place. Yusuf also says that a reform government would terminate all welfare payments to foreign nationals, including the 1.3 million currently receiving universal credit, an increase from 900,000 in 2022. Okay, again, what about immigrants who are naturalised British citizens who started claiming their benefits after they became citizens? Or even before, who have now become naturalised British citizens and continue to claim benefits? Are you going to take benefits away from those people, or are we still stuck with those people and stuck paying their benefits? Because we shouldn't be. And the party is also pledging to replace indefinite leave to remain with a renewable 5-year work visa and a dedicated spouse visa. Okay, we don't need more people. We don't actually want indefinite leave to remain. We don't want an automatic ability for people to get settled status in our country and expedited routes to citizenship. But we also don't want further large-scale work visa programs. We don't need it, especially with the advent of automation and AI. We don't need more low-wage, low-skilled, culturally distant third-world labour. We just don't need it. Reform confirm that this visa ban is just a threat to those countries in its own posts. Quote, Reform UK will impose visa bans on Pakistan, Afghanistan, Eritrea, Sudan and Syria if those countries refuse to take back illegal migrants. Meaning that we will be getting legal migrants from Pakistan, Afghanistan, Eritrea, Sudan, Syria and Somalia, as mentioned in the Telegraph piece, if they take back their illegal migrants. Well, I don't think we need a single legal migrant from those regions. There is not one single legal migrant that is worth taking from those countries to put up with the Pakistani rape gangs, or the very risk that anyone from those countries could perpetrate another violent or sexual crime against the people of our country. We don't need any more of them. In fact, we need millions of them to go home. Zia Yusuf said during his press conference, "We will not consider lifting these bans until they comply and take back their citizens who are in this country legally." Fine, I get it. You're using leverage, but I think it's the wrong leverage to use, because we should just apply the bans and then use other financial sanctions, foreign aid, etc. to get them to comply instead, because we just don't want these people in our country. Their very physical presence is a risk to our women and girls, our way of life, our demographic, security, and our cultural integrity. We just don't need to take any more. There is nobody from Afghanistan, Syria, Somalia, Pakistan, Eritrea, or Sudan that will provide a measurable improvement to Britain, which cannot be provided by a British person themselves. If they could, then their countries would look like Britain, rather than Afghanistan, Pakistan, Sudan, Syria, Eritrea and Somalia. Let's look at what Reform has already offered in terms of mass deportation policy prior to yesterday's announcement. Because what matters most in determining which party we should vote for on the single issue of mass deportations is both what policies are on offer and who are the personnel proposing the policies, and do they have credibility to carry those policies out. And an alarming sign from the outset of Reform's mass deportation policy is that they've said they're only prepared to deport 600,000 migrants. Now, Zia Yusuf's new policy is more optimistic at 288,000 migrants a year. That's well over 1 million within one parliamentary term, and also presuming, of course, some voluntary self-deportations, which the taxpayer won't have to foot the bill for. People will just leave if you turn off their welfare taps, hopefully. But Reform have said it will make £2 billion available to offer payments or aid to countries like Afghanistan to take back its migrants with sanctions potentially imposed on uncooperative countries, like the temporary visa sanctions that Zia Yusuf has already announced. And this was in August 2025. Around the same time that Nigel Farage gave a press conference in which he said, as we'll see later, that still deporting millions of people is a political impossibility, something which clearly he and Zia Yusuf changed their mind on.
Nigel Farage, last September you told GB News that it was a political impossibility to deport hundreds of thousands of people and that we simply couldn't do it. What has changed your mind that you now believe that you can?
The political impossibility was deporting millions and millions of people, and that's where the argument had gone. We had we had a situation, a political difficulty within Reform UK. This does happen to parties. They do have difficulties and problems. We had a problem that one of our MPs, who's no longer an MP, was talking about deporting entire communities, including people who've been born here. And frankly, we found that unacceptable. And so I just did not want, I think you can quote me for another interview, to get dragged down the route of mass deportations at that stage. We have sorted out that political internal difficulty that we had, and since that time, the work has been done on a credible plan so that we can deport hundreds of thousands of people over the 5 years of a reform government.
During the conference, Farage asked Yusuf whether it was realistic to deport 500,000 to 600,000 people within the lifetime of the first parliament, and Yusuf responded totally yeah. Yusuf claimed north of 650,000 adults were already living in the UK illegally and could be deported promptly and efficiently. All of these are quite drastic underestimates, and I'm surprised that Reform at the time didn't have people around them giving them the appropriate data or more accurate estimations of just how many people can be deported from the country in any given parliamentary term. However, this is only for men. It doesn't matter if the illegal immigrants are women and children, it doesn't matter if they are the families of the men who are deported, who will likely launch legal challenges to bring those men back, to reunite those families, because within a day, Nigel Farage clarified that he wouldn't be deporting women and children back to Afghanistan. Just the men. So separating the families, causing yourself a headache in the press, because of course everyone will then complain that Reform's mass deportation policy are breaking up families, which will then cause them to tank in the polls if they don't have their messaging right, which will then cause them, much like the ongoing Trump administration efforts, using ICE in Minneapolis and various Democrat cities, to pause their deportation efforts because they're afraid of being voted out in local elections or denied a next parliamentary term. Yusuf, now the Shadow Home Secretary, said it could deport unaccompanied minors in the latter half of the proposed 5-year scheme, but Nigel Farage said this was not currently part of Reform's plans for a potential first term in office. So we're just going to be stuck with them then. And as it stands, their published policy will not achieve the scale of deportations that are being promised. This is Operation Restoring Justice, which is available on Reform's website. And yes, you're reading it right, it's 6 pages, with 2 of those pages being graphics. So not quite the level of detail required for a mass deportation policy. There are some good points in here, I'm not knocking it. For example, a lifetime re-entry ban on anyone who is deported, who has entered illegally. I presume that also means visa overstayers as well. And the proposal to use the British Ascension Islands, overseas territories, as a detention facility for migrants who refuse to disclose their identity and nation of origin to which they can be deported to. This is a policy that was first proposed by William Clouston and the SDP, and although he's glad that parties adopt it, regardless of whether they give him credit for it, I think we should thank William for his contributions. However, there are a significant number of negative policies and gaping holes in their policy proposal. For example, under the legislation section, it says leave the ECHR, without any further consideration or elaboration on the legal complications that will result from that, which we'll be going through in this podcast. Also, the proposal to repeal the Human Rights Act, which is good, but to then replace it with a British Bill of Rights, which I would say is an inferior option to just reverting to the 1689 Bill of Rights, which served us well until Tony Blair's efforts at constitutional vandalism. Operation Restoring Justice also promises to disapply the 1951 Refugee Convention, the UN Convention Against Torture, and the Council of Europe Anti-Trafficking Convention, but it doesn't recognise that such language is already embedded, without direct attribution, in various bills that have been passed domestically. This is something that Restore Britain's mass deportation papers has done, and as of yet, Reform UK hasn't acknowledged this legislative hurdle in the way of conducting mass deportations. This is the problem of rushing policy out the door without enough detail. And I think that they rushed this policy out the door because of Nigel Farage's previous statements flip-flopping on whether or not the party will actually conduct mass deportations.
It's a political impossibility to deport hundreds of thousands of people. We simply can't do it. At the moment, it's a political impossibility.
But is it your ambition?
No.
Everyone that comes illegally will be deported, full stop, end of story.
I'm not going to get dragged down the route of mass deportations or anything like that. Yeah, I mean, people are always going to come and go, And we are a country that's engaged in international trade, and we have relationships around the world through the Commonwealth, etc. But yeah, we have to aim at a balanced migration policy.
But net zero still means hundreds of thousands of people coming into Britain, immigrants coming into Britain. Isn't that too many?
It may well be, but we have to start somewhere.
If you read different on X over the last few weeks, sponsored by Indian bots, I suggest you ignore it. I will reiterate, nobody that comes into our country on the back of a lorry or via a boat will ever be given refugee status, will ever be given leave to remain.
As Trump says in America that he wants mass deportations, we're talking about hundreds of thousands of illegal immigrants are in Britain at the moment. Some estimates say the number could even be in, 1 million plus. So do you support deporting all of those people?
It's impossible to do. Literally impossible to do.
There's also the promise to offer legal migrants financial incentives to self-deport, and I don't think this is necessary. I don't think the British taxpayer needs to provide pocket money and flights for illegal immigrants and foreign criminals. I think instead, what you do is you notify them you have X amount of months to leave before immigration enforcement will forcibly remove them, meanwhile creating a hostile environment, making it impossible for them to rent and work, and making sure that they can't claim any benefits. And so, if these individuals then turn to crime to support their continued stay in our country, well then they're arrested, imprisoned, and deported like any other foreign criminal in our prisons. Telling people to leave of their own accord or else be caught by border force will save the British taxpayer a lot of money compared to proposing a brand new Danegeld, paying these people to go home, rewarding them for breaking our laws. Reform neglecting to mention domestic legislation is also a massive problem because the House of Lords can block anything that isn't explicitly mentioned in a manifesto. This is why you need to roll the pitch, tell the public exactly what you need to do, in elaborate detail, and draft legislation ahead of time, so that per the Salisbury Convention, which is not legally binding but is a custom of the House of Lords, the House of Lords, which is stacked against a reform government, cannot block any legislation that has been voted to pass Parliament by the public. Let's compare this to Restore Britain's Mass Deportations paper written in October of 2025 by Harris and Pitt, which has already been out there for Reform UK to borrow from. On pages 19 to 21 of the 110-page detailed document, Harris and Pitt outlines the domestic legislation that requires repealing and replacing if mass deportations are to be conducted. That includes the Immigration and Asylum Act of 1999, the Nationality, Immigration and Asylum Act of 2002, the UK Borders Act of 2007, the Borders, Citizenship and Immigration Act of 2009, the Equality Act of 2010, which we'll get onto later, and the Illegal Migration Act of 2023. On pages 47 and 48, Pitt proposes the passage of a Great Clarification Act. It's an act which reminds Parliament and the judicial system that Parliament is sovereign and allows Parliament to unilaterally shoot down any rulings from domestic courts which seek to frustrate the agenda of mass deportations. Pitt writes, the purpose of our Great Clarification Act would be to re-emphasise the sovereignty of Parliament, explicitly underscoring its right to overturn judicial decisions with an instant corrections bill, provided it wins a simple majority in the House of Commons. The balance of interest should be further specified to count in favour of the Commons while the Clarifications Bill in question is assessed by the Lords, precisely in order to avoid the sort of tactical delays pursued by activist lawyers. Paradoxically, such a Great Clarification Act would both require and cause a revival of self-confidence among those who sit in Parliament. No longer will ministers or MPs be able to wash their hands of our problems by outsourcing the business of government to offstage actors. They shall have full power, reinforced in primary legislation by a well-worded Great Clarification Act, to shoot down judicial decisions in real time. Complaints that this would somehow violate the rule of law should be dismissed as fatuous. After all, the Great Clarification Act would simply give renewed practical effect to a principle that already prevails in theory, the right of Parliament to make the laws that govern us. Since laws would continue to govern us under our envisioned plans, there would be no such violation. It would also serve to circumvent a non-compliant activist judiciary during the transition period between restoring the judicial appointment power to the Lord Chancellor, the Justice Secretary, and taking it away from the Blairite Judicial Appointments Committee quango, which has stacked our judicial system with Fabian socialists and activist judges. After tackling withdrawal from the ECHR and modifications to the 1951 UN Refugee Convention, which we'll discuss later, Pitt proposes the following logistical measures to ensure that the number of self-deportations, voluntary returns that save the taxpayer money, vastly outweigh the number of enforced returns and immigration enforcement raids. He proposes using the e-visa system to serve as the only accepted proof of residency for non-British and non-Irish citizens, thereby allowing Border Force easier follow-up on specific visas and those holding them who have overstayed their visa and are in the country illegally. He proposes making right-to-work checks far more stringent because a number of people who are self-employed or in gig economy jobs like Uber Eats, Just Eat and Deliveroo drivers aren't subject to those right-to-work checks, which makes them vectors for illegal migrants to be employed in the black economy. This is why you see so many Indians and Pakistanis on mopeds with L plates delivering you cold pizzas in the afternoon. They don't need to be here, we can stop them working, and those that are already working can be caught and they can be deported. At the moment, employers are under no legal duty to conduct right-to-work checks on contractors or self-employed individuals, having been told by the Home Office that where the worker is not their direct employee, for example if they're self-employed, you are not required to establish a statutory excuse. That leaves a large number of people who are working in Britain outside the scope of right-to-work checks, as they're not direct employees. HM Revenue and Customs, HMRC, believes that 1.6 million people, 5% of the working population, are presently working in the gig economy through a variety of alternative employment statuses. Office for National Statistics figures suggest that as many as 4.4 million people are self-employed. These individuals, when contracted by businesses, currently fall outside the scope of the relevant provisions in the Immigration, Asylum and Nationality Act 2006. Earlier this year, the Home Office published an impact assessment on adjusting laws to require employers to conduct right-to-work checks on all employers and contractors, not just direct employees. Estimates indicate that the cost of conducting these additional checks could be as little as £1.75 per employee. Pitt proposes that this backdoor to illegal employment must be slammed shut and that businesses and employers who do business with self-employed persons must be required to conduct right-to-work checks, just as they would for a standard payrolled employee. To stop the illegal migrant food delivery industry, Pitt proposes that facial recognition and right-to-work spot checks must be implemented for all food delivery accounts. Pitt also proposes increasing the fines and maximum prison sentences eligible for company directors who fail to comply with these right-to-work checks. It creates incentives for employers to vet their employees and prevent illegals working for them. He suggests targeted nudge letters from HMRC to repeat offending businesses, reminding them of their obligations to conduct these right-to-work checks and report illegal immigrants. On housing, Pitt proposes that local councils should have the obligation to provide people with housing, which then translates into providing asylum accommodation, removed from law. An amendment should be made to the Homelessness Reduction Act to include a clear statutory exclusion for those with no legal right to reside in the UK. This amendment should create a joint protocol between the Home Office and local authorities to ensure immediate referral of any homelessness claim involving a person without legal status. That has skyrocketed to about 40% of people sleeping on the streets in recent years. Councils should be under no obligation, legal, financial or moral, to house, assist or prevent homelessness for illegal migrants. Instead, responsibility should fall directly on the Home Office, which can provide holding accommodation pending removal, in things like disused RAF bases. Landlords who fail to conduct right-to-rent checks and thereby rent their properties to illegal migrants should have increasing sanctions placed on them, financial penalties and prison sentences, if they fail to report these illegal occupants to the police. And right-to-rent tenancy checks should be conducted at the start of the application process rather than at the end. Given that this system has been so thoroughly abused, and Pitt notes, as of yet, no landlord has received a custodial sentence for unscrupulous practices, allowing illegals to rent their accommodation. GP surgeries should require identification and proof of legal residency in the UK for registration. This would mean that Doctors Without Borders and other such open borders charities can no longer extort the taxpayer for free healthcare for illegals. Biometric and identity verification measures should be in place for opening a bank account as well, to prevent illegal migrants from opening bank accounts and earning money in the gig economy. Pitt also proposes a 25% remittance tax levied on nations who provide a disproportionate number of illegal migrants and also have a disproportionate number of their national economy comprised of remittances, say Somalia or Pakistan or India. I think you can go much higher than 25%, and I'll expand on this later in the section on further policies to ensure that people leave the country, but just starting with 25% allows you to increase the punitive nature of the remittance tax if the country fails to comply. So this is a very sensible measure. Pitt also proposes establishing a voluntary return scheme using an app, targeted advertisements by the government, similar to how the Trump administration retrofitted the CBP1 Asylum application app to be a self-deportation app. In order to ensure that countries take their offending expats back, Pitt proposes increasing the cost on visas for countries who fail to comply. He notes that a standard British tourist visa currently costs just £127 for 6 months. Those nations with large illegal migrant populations must see a significant uplift in this rate to £500 if we allow it at all. The financial opportunity here is significant given the sheer number of tourist visas that are awarded to countries with large overstay rates. This step alone could raise as much as £447 million a year, which amounts to over 2/3 of immigration enforcement's existing annual budget. So using the visa sanctions to fund enforced returns. A recruitment drive is proposed, offering significant pay benefits, university scholarships, and targeted recruitment for veterans and police officers to bolster the amount of personnel involved in immigration enforcement. The 19 existing local immigration and compliant enforcement teams, which make use of local knowledge of HMOs, fraudulent businesses, and other such illegal migrant hotspots, will be expanded. This will allow local residents in non-compliant sanctuary council boroughs like Oxford to tip off the central authorities to the whereabouts of illegal immigrants, even if the local councils do all they can to shield them. Mandatory data collection across all departments, with a synergized database for illegal migrants, similar to what Yusuf has since proposed, will also make it much easier for central government authority to identify illegal migrants, who's taking welfare, where they're living, who's committed crimes, and therefore detain and deport them. The public will also be provided financial rewards for successful tips that result in deportations. £500 for verified intelligence leading to a successful deportation, £1,000 for intelligence that results in the conviction or deportation of an illegal immigrant employer or trafficker, and £2,500 for verified intelligence resulting in the dismantling of an organised illegal operation like a whole trafficking gang. The capacity of existing immigration detention facilities will be expanded using Nightingale Hospital-style detention facilities, pop-up housing encampments, and retrofitting the 38 Royal Air Force bases that have been closed since 1995 into detention barracks, with some having the benefit, of course, of still having operational runways after a bit of repair, so you can do your charter flights straight from the barracks. Both Pitt and Rupert Lowe have also proposed a deportation NATO, an international cooperation effort between countries to ensure that we aren't just passing our illegal migrants like a buck to the previous nation, kicking them back to France, through Germany, making them Europe's problem. Instead, a cross-national effort to put pressure on countries that are recalcitrant to accept their criminal foreign nationals back and icing them out of the global economy, and making sure that none of our fellow countries in Europe or the Anglosphere have to deal with this problem. Because we're concerned about the fate of your demographics and your culture too. Measures would include joint public designation of offending countries, harmonised visa sanctions, foreign aid suspension, targeted trade measures and tariffs, remittance and dividend controls and taxes, reciprocal mobility restrictions for their diplomats or their elites, rapid response returns task force, so if one country finds it difficult to return their nationals, another country can help them out, and sanctions on document fraud facilitators, finding criminals, freezing their assets, seizing them, and putting them to good use to actually fund the deportations. Pitt notes that Britain is uniquely placed to lead such a coalition. Initial membership would likely consist of nations already aligned on border enforcement, intelligence cooperation and migration control: the United States, Canada, Australia and New Zealand. France, Germany, Italy, Denmark, the Netherlands and Greece. Several Central and Eastern European states, Poland, Hungary and the Czech Republic, have already voiced support for tougher deportation frameworks and would likely join. The coalition could also coordinate with non-EU European partners such as Norway and Switzerland. Collectively, this bloc would represent the overwhelming majority of the Western world's desirable destinations for economic migration, giving it immense leverage over recalcitrant states. This is what Rupert Lowe has been posting about in recent days. I would like to see countries with similar values come together in a formal way to apply pressure, economic, legal or otherwise, on those nations that refuse to accept the deported criminal aliens. Who could form this alliance? Britain, the US, Australia, Canada, Sweden, New Zealand, Denmark, Italy, Hungary, Poland, I could go on. If Pakistan refuses to accept a Pakistani child rapist from the UK, if Colombia refuses to accept a Colombian murderer from the US, allied countries should show a united front. Suspend all foreign aid, enforce visa sanctions, impose emergency tariffs, deliver financial penalties, apply diplomatic pressure, pursue legal action, and more. Do it swiftly, do it brutally, and do it together. Not just from one or two countries, but from dozens. Watch how quickly these challenging nations fold then. Set an example. It would only have to happen once, and an incredibly effective deterrent would be established. NATO's Article 5 for deportations, if you like. We should not tolerate belligerent administrations refusing to accept their own deported criminals. Quite simply, they are your problem. We do not want your criminals in our prisons, in our communities, in our countries. If the return isn't accepted, this deportation alliance will ensure that there is hell to pay and it wouldn't happen twice. Pitt also proposes resurrecting the idea of a Rwanda-style third country detention scheme, deporting criminal foreign nationals to a third country if they refuse to disclose their nation of origin. Britain should enter negotiations simultaneously with several nations with a view to securing multiple agreements within the early days of a new government. And unlike the Rwanda scheme, it won't be a health tourism plan where we take one Rwandan for every illegal migrant we send over there, and we pay for their bed and board the entire time, and if they commit a crime, then Rwanda can decide at their disclosure to send them back to us. Also, unlike Reform UK, Pitt proposes retrospective action, the complete withdrawal of asylum grants from all illegal entrants over the last decade or more. All asylum and humanitarian protections granted to individuals who entered Britain illegally within the last decade should be rescinded in full, and those individuals deported within a reasonable time period. Any individual arriving illegally would also be subject to immediate processing and deportation within 24 hours, either to their country of origin or a designated safe third country. Clear statutory authority and pre-arranged logistics would make such removals automatic and immediate. You could also, as Rupert suggested, use a windswept island off the coast of Scotland and give them the basic necessities until they disclose their nation of origin and return home accordingly. Pitt also provides a more optimistic cost saving and deportation timeline estimate than Reform UK. Assuming a cautious ratio of 3 voluntary exits for every forced exit, resulting from the hostile environment proposed by the logistical measures I just listed, together with a similarly cautious annual average of 150,000 forced deportations, 3 million people would be removed within a single parliamentary term. It would therefore take exactly 3 years to deport 1.8 million, which we regard as close to the true number of illegals in Britain. Our second realistic estimate is more impressive. It assumes the same 150,000 forced deportations every year, but this time with a Trump-style 4.1 ratio of voluntary to involuntary removals. We'll get on to the accuracy of those stats later, but for the sake of the model, we'll assume that it's the case. In short, this would see 3.75 million deported within a single parliament. Given our illegal population is more like 2 million, this is obvious overkill. Suffice it to say then, that assuming such a ratio with such a scale, it would take around 2 years and 5 months to deport 1.8 million illegals. During the most daring estimate, which assumes quite a plausible scenario, a Trump-like 4.1 ratio of voluntary to involuntary deportations, together with a near-perfect detain-to-deport record 95% that sees 185,000 illegals removed each year. In such favourable circumstances, it would take fewer than 2 years, 1 year and 11 months, to deport 1.8 million illegals. We estimate the total number of illegal migrants in Britain falls somewhere between 1.8 and 2 million. Given our ultimate preference for the realistic estimate given above, we have full confidence that, courtesy of our proposals, mass deportations would be achieved in well under 3 years, if not sooner. And that's without touching legal migration, which is the topic of an upcoming paper by Restore Britain. The proposed costs for this plan are between 49 billion and 57.6 billion. The upper estimate is assuming a pessimistic 5-year period for the returns to be conducted and a ratio of 3 voluntary exits for every 1 enforced exit. But the total annual savings of the plan, assuming 1.5 million illegal adults and 300,000 illegal children currently reside in Britain, are 7.16 billion to the taxpayer. Pitt notes it should be added this figure is incredibly conservative since it does not include the considerable secondary economic effects recounted above. A further 5.38 billion using 2023 and 2024 figures is saved with the abolition of the asylum system, the overall savings of enacting this deportation plan would be at least $12.5 billion a year, with Reform UK's Dame Andrea Jenkins, when she was still a Conservative MP, revealing in May 2024 that the total cost of the asylum system in the previous year was £14.4 billion. It's clear that Reform UK are borrowing from this paper without attribution, and I think that's fine, because no matter which party becomes the next party of government, I'm glad that a credible plan for deportations is being built. But the problem with credibility is who are the people carrying it out, and can they be trusted to carry it out, given they have been inconsistent on their commitment to mass deportations in the past? And are the parties responsible capable of implementing this? Are they going to run into legal and civil service challenges that they aren't prepared for? First, let's address the European Convention on Human Rights, and why we need to leave it. We should definitely leave the ECHR, an instrument that was once designed to protect Dutch Jews fleeing the Holocaust on the Kindertransport is now affording sanctuary to the worst kinds of sex criminals from Albania, Afghanistan, Pakistan, the Middle East, and Africa. This is because of Articles 2, 3, and 8. Article 2 affords everyone the right to life and says everyone's right to life shall be protected in law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. Deprivation of life shall not be regarded as inflicted in contravention of this article when it results from the use of force which is no more than absolutely necessary, in defence of any person from unlawful violence, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained, and in action lawfully taken for the purpose of quelling a riot or insurrection. Unfortunately, deportations to another country, where the person in question may face the death penalty for their crimes, is not included as a legitimate reason to violate Article 2 under Article 2. Article 3 is the prohibition of torture, that no one shall be subjected to torture or to inhuman or degrading treatment or punishment, and under UK law, that article is absolute, as we'll come on to in a moment. And Article 8, which is the most common one for illegal migrants seeking to frustrate their deportation to appeal to, is the right to respect for privacy and family life. That everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority with the exercise of this right except such as in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. There's a lot of wiggle room there for judicial interpretation to ensure that foreign criminals can be deported, and their appeals to Article 8 do not succeed, but the interpretations are far more liberal, and because of the way that judges have been appointed, and because of the way that the ECHR is supreme over domestic law in British law, the criminals always come out on top in the appeals. Some of the most egregious examples, as reported by The Telegraph, include a Pakistani paedophile who was not deported because he claimed it would harm his children. A tribunal judge ruled he should not be deported back to Pakistan because it would be unduly harsh for the children to be without their father. So a paedophile was allowed to stay in our country because it would be unfair if he didn't have access to children. There was also another Pakistani paedophile who was allowed to stay because he's an alcoholic. It was judged that it would amount to a breach of his rights under Article 3 of the European Convention on Human Rights, which prohibits torture, inhuman or degrading treatment, because if he returned to Pakistan, a Muslim country, he wouldn't be able to drink. An ISIS-supporting Iranian illegal immigrant who entered Britain illegally on a small boat in March 2021 and claimed asylum. He had previously been granted 5 years leave to remain as a refugee in March 2017 after crossing the English Channel in the back of a lorry. This was revoked by the Home Office in April 2020 after he visited Iraq, prompting concerns that he was a danger to national security. After entering for a second time, he was detained in an immigration jail, but a judge released him on bail in June 2022, after he found detention had caused or aggravated his depression. But in July 2022, the Home Office rejected his second asylum application on national security grounds, after asserting he had an Islamist mindset and maintained support for Islamic State. But despite revoking his refugee status, the Court of Appeal decided that the government could not deport him back to Iran because he would face persecution and torture, which would violate Article 3. So we have to keep ISIS terrorists in our country, just milling about with no legal status, because if they return to Iran, they will be persecuted for being part of a different Islamic sect. A Palestinian woman won the right to be resettled in Britain because she argued that if she wasn't allowed to be reunited with her son, who was already living in the UK, this would violate her Article 8 rights under the ECHR. She's Palestinian. Why does she have European rights? And of course, the most infamous example, the Albanian criminal who is allowed to stay in our country because he said his son doesn't like the taste of foreign chicken nuggets. It's obvious that the ECHR is providing undue leniency to criminal foreign nationals at the expense of law-abiding tax-paying Brits. But why can other countries selectively ignore ECHR rulings? Why is Britain always beholden to the decisions from the Strasbourg Court? Well, it's a mix of foreign and domestic law, and law which even predates the passage of the 1998 Human Rights Act. For example, in the case of Chahal versus the United Kingdom, a Sikh separatist Khalistani nationalist was in the UK and eligible to be deported, and he petitioned that his deportation would be unlawful under Article 3, the right to not be tortured. The court ruled in his favour in 1996 against the UK government and said that the criminal activities of an applicant protesting his deportation under Article 3 could not be taken into consideration. Quote, "The prohibition provided by Article 3 against ill treatment is equally absolute in expulsion cases. Thus, whenever substantial grounds have been shown for believing that an individual would face a real risk of being subjected to treatment contrary to Article 3 if removed to another state, the responsibility of the contracting state to safeguard him or her against such treatment is engaged in the event of expulsion. In these circumstances, the activities of the individual in question, however undesirable or dangerous, cannot be a material consideration." It also notes that Article 3 corresponds to obligations in Articles 32 and 33 of the 1951 UN Refugee Convention. So even if we just repeal the Human Rights Act or disapply it, there are ECHR decisions that exist on British statute books that mean that we can't deport foreign criminals and we can't use their crimes as grounds for deportation if they claim they will be persecuted in their home countries because of their own behaviour. There's also the 2001 case of Sen v. the Netherlands. The applicants in this were Turkish national Zeki Sen, his wife Gulden Sen, and their daughter Sinem Sen. Zeki and Gulden had settled in the Netherlands, leaving their daughter behind in Turkey. They then applied to grant her residency in the Netherlands when she was 9, and they appealed the refusal of their daughter Sinem's visa via Article 8 of the ECHR. The court then ruled that ECHR member states have a positive obligation to facilitate family reunification. Now, in the UK context, I would guess this is the precedent cited by Justice Yip in HS and ZN versus Foreign Secretary in 2024 that allowed Afghans to import their entire clan into our country. One member imported 22 of his extended family and clan members into the country because Justice Yip said the term family member does not have any fixed meaning in law or in common usage. Indeed, the word family may mean different things to different people and in different contexts. There may be cultural considerations. There is no requirement for a blood or legal connection, meaning that our positive obligation under the ECHR, under Sen v. Netherlands, could imply an obligation for us to import via chain migration entire third world clans into our country. Now, it's important to note that Sen v. the Netherlands does not prohibit any legal migration restrictions placed on family reunification visas. The 2020 case upheld the decision to deny an Indian national a reunification visa for his wife during the COVID lockdowns, when red list travel restrictions were imposed, despite the judge acknowledging the implications that Sen v. Netherlands had on reunification visas in relation to Article 8. There was a Sri Lankan national who appealed their deportation order, citing Sen v. the Netherlands to argue their return to Sri Lanka would separate their older and younger daughters, thereby violating Article 8, but this was dismissed. So Sen v. Netherlands has not been absolute when it applies to legal migration cases in the UK, but it does mean that there is a positive obligation to facilitate family reunification on our statute books so long as we remain a part of the ECHR. Case law like this is why, during the drafting of the Illegal Migration Bill of 2023, ministers submitted as part of their evidence that, quote, Article 8 of the ECHR does not automatically guarantee a right to family reunification, but provides a broader protection of the right to a family life when the court considers whether the refusal to admit family members into the state territory constitutes a justifiable interference with the right to respect for family life. It would be far easier just to leave the ECHR and not have to deal with this legislative headache and constantly twist ourselves into pretzels to try to remove people from our country and prevent mass chain migration, while holding to some positive obligation to facilitate chain migration as part of Article 8's right to family life. And the reason Britain is subordinate to the European Convention on Human Rights and the Strasbourg Court, whereas other nations aren't, is because of Tony Blair's Human Rights Act 1998, which enshrined the European Convention on Human Rights and the supremacy of the Strasbourg Court into domestic British law. Under Section 2, Interpretation of Convention Rights, it says a court or tribunal in Britain determining a question which has arisen in connection with the Convention must take into account any judgment, decision, declaration, or advisory opinion of the European Court of Human Rights, or opinion or decision of the Commission given in a report adopted under Articles 31, 26, 27.2, or Article 46 of the Convention. And that last one is the most important. Section 3, regarding the interpretation of legislation, says, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights, so Parliament cannot currently pass legislation which violates the European Convention on Human Rights, which means that any deportation effort will not pass Parliament if a successful legal challenge can be brought against it using the European Convention on Human Rights. Section 6, concerning public authorities, also says it is unlawful for a public authority to act in a way which is incompatible with a convention right. So, any effort to conduct mass deportations with the European Convention on Human Rights and Human Rights Act still on the books will be shot down. And as Harrison Pitt points out in his mass deportation paper, this was by design. This report, Rights Brought Home, was presented by the Blair government as the justification for the passage of the Human Rights Act. Under the case for incorporation, the Labour government says that the purpose of the Human Rights Act is so it will also mean that rights will be brought much more fully into the jurisprudence of the courts throughout the United Kingdom, and their interpretation will thus be far more subtly and powerfully woven into our law. The express purpose of the 1998 Human Rights Act was to subordinate parliamentary sovereignty to the European Convention on Human Rights and the European Court of Human Rights. This means that Britain is no longer subject to the rule of law, because Parliament is not supreme and cannot pass any law it likes. Instead, it is subject to the rule of lawyers who interpret ECHR law and tell the government what it can and cannot do. Rulings from the ECHR are mistaken because Article 46 is given supremacy in British law over British law. Article 46 states that the countries that are signatories to the European Convention on Human Rights are subject to final judgments by the European Court on Human Rights. Basically, what the court says goes. So the Human Rights Act means that any judgment by the European Convention on Human Rights binds Parliament, meaning that the court, not the voters and elected ministers, run our country. Articles 32 and Articles 34 also impose further restrictions on national sovereignty. Article 32 describes the jurisdiction of the court and says, the jurisdiction of the court shall extend to all matters concerning the interpretation and application of the Convention and the protocols thereto which are referenced to it as provided in Articles 33, 34, 46 and 47. Articles 33 and 47 concern interstate disputes and the ability for the court to seek advisory opinions on extra-legal matters in cases brought before the court, but Article 34 concerns individual applications and states, the court may receive applications from any person, non-governmental organisation, or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the Convention or the protocols thereto. The high contracting parties undertake not to hinder in any way the effective exercise of this right. Basically, anyone with a grievance can bring a case before the court, and the countries that are signatories to the European Convention on Human Rights have to accept the judgments of the courts as final under Article 46. And one of the most absurd rulings relates to climate policy in 2024, when 4 female pensioners, one who died during the proceedings, brought a case against the nation of Switzerland using Article 34, saying the country's slow progress on meeting its net zero emissions goals by 2050 meant that it violated their Article 8 rights to a private and family life. The applicant's complaints included that one applicant had collapsed during a heatwave and had adapted her habits to the heat by going to the shops earlier and getting fresh air at night, and this limited her social environment. Another said that during heat waves she had to stay at home and take the appropriate medication. Fifth applicant said that during the summer she could not face leaving her home and going for a swim. At the same time, she could not afford to take longer holidays in a hotel with a swimming pool. She had never been hospitalised and had not seen a doctor in relation to the heat waves. Previously, she'd also worried about her 90-year-old mother, until the latter had moved away to a place with a better climate. So because rich boomers couldn't sit by a pool in their 70s for prolonged durations without the assistance of air conditioning, a fan, or an umbrella, this apparently violated their Article 8 rights under the European Convention on Human Rights. And therefore now every member state that is a signatory of the European Convention on Human Rights has to proactively ensure they reach net zero emissions by 2050. Because it's too hot for pensioners to take holidays, every member state of the ECHR now has to spend billions on sabotaging their domestic energy production and manufacturing capacity to reach net zero emissions, while China, India and the rest of the third world are still burning coal. So unless we leave the ECHR and repeal the Human Rights Act 1998, our immigration policy is still held hostage by ECHR rulings under Article 46. The process to leave the ECHR has been outlined by former Conservative Home Secretary and Attorney General, now Reform UK's education spokeswoman Suella Braverman, and Guy Dampier in their paper for the Prosperity Institute. On page 7, they recommend invoking Article 58 of the ECHR, which begins a 6-month countdown to leaving, preparing our domestic legal framework for the end of the ECHR through a bill to repeal the Human Rights Act 1998 and a temporary case law review commission under a sunset clause to examine what Strasbourg-influenced case law should be retained, amending the devolution settlements to remove reference to the ECHR, amending reference to the ECHR in the UK-EU Trade and Cooperation Agreement, ideally negotiating technical amendments to replace these. This alongside, of course, a renegotiation of the post-Brexit trade deal to ensure that EU nationals cannot receive benefits, as the Yusuf promised on Monday. Amending the Belfast Agreement, also known as the Good Friday Agreement, with the Northern Ireland Protocol and the Windsor Framework, and clarifying that a combination of the common law and statute provides ample protection of civil liberties in the United Kingdom to ensure there isn't a constitutional crisis over Northern Ireland and the Republic of Ireland and the Belfast Agreement. This will require amendments not just to the Scotland Act of 1998, the Government of Wales Act 1998, and the European Union Future Relationship Act 2020, and other legislation which the ECHR has referenced, but also, as mentioned, the Belfast Agreement 1998, which affirmed Northern Ireland's status as a continued part of the United Kingdom, and the Windsor Framework, which prevented a hard border being erected between Northern Ireland and the Republic of Ireland following Brexit. The Belfast Agreement was signed before the Human Rights Act 1998, so repealing that shouldn't affect it, but language from the ECHR is woven into the Belfast Agreement. Braverman and Dampier assure us that crucially, while the agreement commits to incorporation, it does not prevent the UK Parliament from repealing the Human Rights Act 1998, nor does it prohibit the UK from denouncing the ECHR under Article 58 of the ECHR itself. As such, the agreement respects the constitutional doctrine of parliamentary sovereignty, even while it promotes a normative human rights agenda. The problem is, will the signatory nations, the Republic of Ireland, who remain a part of the EU, and the ECHR, accept the renegotiation? Are they going to accept the withdrawal of the UK from the ECHR, while also attempting to guarantee ECHR-style human rights provisions under the Belfast Agreement? Dampier and Braverman insist the reform process must be grounded in consultation with Northern Ireland's communities and its main political institutions, but it must also reflect the UK Parliament's ultimate sovereignty, particularly in constitutional matters. And this will be the subject of their case law review, looking at which ECHR statutes the government should retain as guarantees between Northern Ireland and the Republic of Ireland, that the Belfast Agreement's ECHR protections will be honoured in spirit, if not in letter, once the UK leaves the ECHR. But this paper is actually very light on detail as to which specific statutes and rulings under the ECHR should be retained on British books. Pitt, in his mass deportations paper for Restore Britain, actually provides a list of some examples where the ECHR has ruled in favour of religious freedom, mediating differences between different Christian sects, like the Protestant and Catholic dispute between the Republic of Ireland and Ulster. So this is actually a helpful list that Pitt has provided for an incumbent reform government, if Restore doesn't surpass them and form the next government, and it's something really that Braverman, who is now a member of Reform UK, and the other lawyers and policymakers over at Reform UK should have already done. So this does lend credibility to Restore Britain proposing that they have a stronger case for conducting mass deportations, because they actually understand the extent to which the law must be revised, repealed and replaced in order to get mass deportations done. Speaking of which, Harrison Pitt's paper places a lot more focus on the 1951 UN Refugee Convention than Operation Restoring Justice or any of Reform's other policy offerings. This is important because the definition of a refugee under this convention is insane, and we cannot continue to hold to it. A refugee, according to the convention, is someone who is unable or unwilling to return to their country of origin, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. That is so broad that even if we remove the Human Rights Act and membership of the ECHR from our statute books, continuing to be a member of the UN Refugee Convention will frustrate deportation efforts, especially when its language is encoded in domestic law. So we would either need to revise our membership of this or use pressure from our allies in the United States to amend the Refugee Convention to ensure that all refugees have to seek asylum in their continent of origin. This means that not only will Britain cease to receive refugees and fake asylum seekers from the Third World, but it also means that Britain's asylum system will come to a halt overall, because per the Dublin Agreement, refugees will then seek asylum in their first safe country, and those in Europe will seek asylum in the neighbouring countries of Europe. And that means that, at most, Britain will only receive refugees from countries like Norway or France, and the likelihood of that is pretty low. Our ability to pass any of these legal changes is also contingent on our ability to get rid of the public sector equality duty, which creates activist unions in the civil service that will frustrate the agenda, the ability to hire and fire civil servants, because currently the Civil Service Code is written into law, and it stipulates that any attempt to do so constitutes political interference by elected ministers in the permanent bureaucracy that actually runs the country, and the removal of the Supreme Court, and the reform of judicial review to prevent mendacious lawsuits from being brought forward by activists and members of the public seeking to overrule parliamentary sovereignty. So we need to repeal the Equality Act, 2010, the Constitutional Reform Act, 2005, and the Constitutional Reform and Governance Act, 2010. Liz Truss, Suella Braverman, David Starkey, and Dominic Cummings, people who agree on basically nothing between them, have all said this, so this certainly seems to be at the heart of the problem. And Suella Braverman, after taking office as Reform's Shadow Education Secretary, has written the following piece for The Telegraph saying that Reform is committed to repeal the Orwellian Equality Act. She says where the Equality Act went wrong was to embed a far more expansive doctrine of state-mandated social engineering, one influenced heavily by the law of the European Union and European Convention on Human Rights. Consider the public sector equality duty in section 149. Its language appears innocuous, even virtuous. Who, after all, could object to fostering good relations? But in practice, it has placed public authorities under the intense pressure not to merely avoid unfairness, but to demonstrate positive discrimination, the antithesis of a meritocratic society. Combined with the positive action measures in sections 158 and 159, what started as a shield has now become a sword in the culture wars. This is the reason why the Royal Air Force and the Met Police have discriminated against straight white men and said, we don't need any more useless white male pilots. This legislation has rendered us second-class citizens in our own country, but it's also established grievance-mongering unions and public sector bodies that agitate for sexual, sectarian, and racial concerns, and thereby will block mass deportations, if left unaddressed. Group rights, diversity targets, and positive discrimination will be out, Suella promises. We will restore the oldest and most British of principles, that every person is equal before the law, and that no person may be treated unfairly because of who they are. I like this promise, but when Victoria Derbyshire on BBC Newsnight presses Zia Yusuf, the man that Reform want to put in charge of mass deportations, on how the Equality Act will be repealed, he essentially concedes to all of her premises and says that the Equality Act will be repealed in name only, but all of the same protections will remain in place.
So which of the protected characteristics do you not want to protect anymore? Because I'm not clear.
Well, as I said, we've got to look at why. I'm going to keep saying it because it is a huge problem in this country. They are left behind. White working class boys
no, forgive me. The question was specific. Which do you not want to protect? Is it sex?
Well, hold on.
I'm going to go through the list.
Well,
will you protect sex?
But you've got to look at how all of these things work together. With respect, you can't reduce a serious conversation like this to 2 minutes.
Forgive me. I am not reducing anything. I am literally going to go through the protected characteristics and ask what a reform government. Okay. Whether the reform government would protect them in the future or not. The fundamental problem with the line of questioning here is that you're not going to ask me about the fundamental point that I'm making, which is that, for example, social class is not listed or mentioned in that at all. I'll ask you in a moment. Are you going to protect sex?
we believe that regardless of your biological sex, you should have an equal right to a job.
Okay, are you going to
now
protect...
whether that
Okay, I'm sorry, we've got a list here.
Okay, fine, go ahead.
Are you going to protect sexual orientation?
Yes, those things. Well,
disability.
Again, but we've got to be clear about what we mean when we say protect, right? Because the way the Act is drafted, again, there are a lot of things that are positive duties that are placed on people like employers, for example. There are laws in other statutes, by the way, that protect people from discrimination. But we've also got to be clear that the way the Act ends up functioning is as a result of all of these things being put together. So if you're going to try and create an exhaustive list...
It consolidated a lot of legislation.
Yeah.
Disability.
We've already covered that, yes.
Race.
Yes, we would
religion.
Protect that. Hold on. So I want to make the point again. If we go through every type of...
there aren't many left.
The problem Yusuf has is he is unwilling to say anti-discrimination law is not the purview of the government. Now, he could just say we will revert to the Sex Discrimination Act, which predated the Equality Act, which prevents men from going to women's spaces if they're wearing a dress. He could say we can legislate to ensure there are some protections there for disabled people, but otherwise we're not in the business of protecting people from having hurt feelings on the basis of race, religion, or belief. And he doesn't say that, which means that if those protections remain, despite a repeal or disapplication of the Equality Act, then the same grievance bodies will remain in the civil service. For example, the 700-strong Islamic network in the Home Office, whose members have brothers and friends who joined ISIS, and despite this, they say that Prevent is inherently racist because it focuses on jihadist terror, or who have taken bribes to overturn rejected asylum applications from Bangladeshis, while also denying asylum applications from Christians fleeing forced conversion and persecution in Muslim countries. If these people are still employed in the Home Office, mass deportations will not get done because personnel is policy, and the civil service matters just as much, if not more, than the elected politicians promising to carry out the policy, but who won't get it past the civil servants who don't want to do it. Yusuf, unlike Suella Braverman, failed to mention the public sector equality duty which allows these groups to exist. Under the Equality Act, Part 1, the public sector equality duty regarding socioeconomic inequalities is defined as an authority to which this section applies must, when making decisions of a strategic nature about how to exercise its functions, have due regard to the desirability of exercising them in a way that is designed to reduce the inequalities of outcome which result from socioeconomic disadvantage. Explicitly Marxist language, presuming that we are all blank slates, that we all begin from an original position of equality, and that society has been set up in an unjust fashion which makes us unequal, so it is the job of the public sector to rectify inequalities by discriminating against majorities in favour of minorities. And so any minority group which can have a plausible claim to being treated unequally, to having an unequal outcome which therefore is proof of oppression, has resources and protections afforded to it by the state, meaning that immigrant groups and the various foreign religions and ethnicities that form ethnic blocs and sectarian blocs to petition on behalf of their ethnic and religious interests will continue to have purchase within the state and will continue to block mass deportations unless this is repealed. These protected characteristics include age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation, with race defined as nationality or ethnic or national origins. So you can't discriminate against someone because of their national origins or nationality, meaning that no law can draw distinctions between British nationals and foreign nationals, or those born overseas and given British citizenship versus those who have inherited British citizenship from their native parents, so long as the Equality Act remains on the books, so long as racial discrimination as defined by the Equality Act remains on the books. So Reform UK will not be able to do its removal of benefits from foreign nationals and foreign citizens so long as they commit to the tenets of the Equality Act, whether they repeal it in name only or keep it on the books and just disapply it selectively. The whole thing's got to go. A full repeal, by the way, is what's being promised by Restore Britain. So they will actually achieve what they've said. The public sector equality duty is under Part 11, the advancement of equality, and it describes the duty as a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, harassment, victimization, and any other conduct that is prohibited by or under this Act, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, and foster good relations between persons who share a relevant protected characteristic and persons who do not share it. So the obligation to foster good relations is the obligation to manage community cohesion. It's the same excuse that police officers and public sector bodies used to cover up the Pakistani rape gangs. It also says, regarding the advancement of equality of opportunity between persons who share a protected characteristic and persons who do not share it, that due regard involves the need to remove or minimize disadvantages suffered by people who have protected characteristics and those who don't, taking steps to meet the needs of persons who share a relevant protected characteristic different from the needs of persons who don't, and encourage persons who share a relevant protected characteristic to participate in public life or in any other activity in which participation by such persons is disproportionately low. It means that the regard of the government and all public bodies is expressly for minoritarian concerns at the expense and to the exclusion of the majority. We just need to get rid of this to change the entire philosophy of government. It notes that compliance with the duties in this section may involve treating some persons more favourably than others, but that is not to be taken as permitting conduct that would otherwise be prohibited by or under this Act. Basically, you can discriminate against straight white men in favour of sexual, racial and religious minorities, and therefore treat British people as second-class citizens in their own country, denying them representation in their own government. But just repealing the Equalities Act is not enough. You also have to repeal the 2011 Charities Act, which stipulates that the government, in order to fulfil its statutory equalities duty, must funnel money to the NGO grievance industrial complex. Passed by the last Conservative government, by the way, the 2011 Charities Act defines a charitable purpose as the advancements of human rights, conflict resolution or reconciliation, or the promotion of religious or racial harmony or equality and diversity. DEI is explicitly the business of state under the Equality Act and the Charities Act. If you're not getting rid of the Charities Act, you will continue to have an NGO industrial complex agitating for the blocking of mass deportations, funded by the same government that's trying to carry it out, enabled by the same civil servants tasked by that government with carrying it out. You need to dismantle the activist state, and doing so requires the removal of the Charities Act. Otherwise, mass deportations won't happen. Otherwise, Zia Yusuf's proposed Polanski law, a law that makes it illegal to perform any act that assists in legal entry into Britain, which would target organisations like Care for Calais, will not pass Parliament, or at least it won't be enforced by the courts, because the courts will say that these NGOs have been deputised by the government to fulfil its statutory equalities duty and their charitable purpose per the Charities Act 2011. Those acts need to go, otherwise mass deportations will not happen. Otherwise you won't be able to criminally prosecute people who are facilitating people smuggling efforts from Britain or in Calais, funded by the taxpayer. And you won't be able to do any of this unless you repeal the Constitutional Reform and Governance Act 2010, which enshrines the Civil Service Code into law, which means that the civil service are unaccountable. It means that any attempt to hire or fire a civil servant will be considered an act of misconduct in public office, because the relevant minister is politicising the civil service department they are trying to hold to account, and therefore they are breaching the Civil Service Code. Section 5, Civil Service Code, says the Minister for the Civil Service must publish a code of conduct for the civil service excluding the diplomatic service, and a Civil Service Code forms part of the terms and conditions of service of any civil servant covered by the code. What constitutes this code? Well, under Section 7 it says, this section sets out the provision that must be included in a civil service code or the diplomatic service code in relation to the civil servants covered by the code. The code must require civil servants to carry out their duties with integrity and honesty, and with objectivity and impartiality. That means that the government of the day cannot interfere with the business of the civil service, otherwise it violates the Civil Service Code. Translation, the government can't hire and fire civil servants, and civil servants can't be political appointments, meaning they can't be accountable to ministers. Meaning a permanent bureaucracy actually runs the country, and they can get rid of elected ministers, but elected ministers can't get rid of them. The other problem with removing civil servants comes with the Budget Responsibility and National Audit Act 2011, also passed by Cameron's Conservative government, which says that the Office for Budget Responsibility must exist to continue to ensure fiscal best practice is followed by the Treasury. It means an unaccountable quango governs fiscal policy in our country, and they do it badly because their projections on tax receipts and net migration have been routinely wrong. The problem with this is that Reform Shadow Chancellor Robert Jenrick has already promised not to abolish the OBR and to keep the Bank of England independent, a move that Gordon Brown did while Tony Blair's Chancellor in 1997. This means that any reform government will be hostage to the bond markets. This means that they can't hire and fire civil servants because budgets are made annually and civil servants are given a year of severance pay minimum, meaning any reductions in the civil service to cut costs and make the civil service more efficient will be advised against by the OBR because no savings will be made in a budgetary year. So without liquidating the OBR, it's impossible to shrink the state. And Reform UK, probably to ease the anxieties of the bond market upon coming into government, have already committed to not abolishing the OBR. Also, Robert Jenrick ran his budget past Cameron's Chancellor George Osborne, saying he hopes for his approval. I think Reform are drastically underestimating the resistance they're going to meet upon impact with the civil service, and so, at present, are not prepared to conduct mass deportations because they're not prepared to grasp the nettle of the civil service and the unaccountable institutions that actually run the British government, thanks to Tony Blair, David Cameron, Theresa May, Boris Johnson, Rishi Sunak and Keir Starmer. They make it very difficult to leave the ECHR, by the way, because any revisions to the Windsor Framework or the Belfast Agreement will spook the bond markets because of fears of a hard border between Northern Ireland and the Republic of Ireland, or even mass deportations themselves, because the Bank of England and the OBR are addicted to a GDP growth at all costs model, and they're growing GDP at 0.1% per quarter just by shoving more people into the country, therefore increasing the amount of money that changes hands, therefore increasing the GDP while shrinking GDP per capita. And so mass deportations and net emigration, net migration every year going up, will shrink the GDP, even though it's not a good metric of economics, and the OBR and Bank of England will advise against that because they are running a deficit, and in order to increase their borrowing to meet existing pension and social care spending commitments, they need to grow the GDP, which is only grown by increasing immigration. So if Reform aren't prepared for this, they will find themselves, like Boris Johnson did, engaging in human quantitative easing, increasing migration, to soak up excess inflation and not spooking the bond markets, causing the state to become insolvent when they don't want to service their own debt under Richard Tice's recommendations. You also won't get any of this done without judicial reform, repealing the Constitutional Reform Act 2005, which, as it describes, is an act to make provision for modifying the office of Lord Chancellor, Justice Secretary, and to make provision relating to the functions of that office, to establish a Supreme Court of the United Kingdom, and to abolish the appellate jurisdiction of the House of Lords, to make provision about the jurisdiction of the Judicial Committee of the Privy Council, and the judicial functions of the President of the Council, to make other provision about the judiciary, their appointment and discipline, and for connected purposes. Translation, this means the judiciary are unaccountable to the government as well. Under Section 3 it says, the Lord Chancellor, other ministers of the Crown, and all with responsibility for matters relating to the judiciary or otherwise the administration of justice, must uphold the continued independence of the judiciary. Translation, judges appoint other judges, not the elected minister that serves as Lord Chancellor. Which means that you can't remove activist judges that will try to block your manifesto pledges. You can't remove activist judges who give lenient sentences to sex offenders or prevent the deportation of criminal illegal migrants. Abolish the Supreme Court, return the duties of appointing or removing judges to the Lord Chancellor, and abolish the Judicial Appointments Committee. Otherwise you'll get nothing done. Douglas Carswell, the former UKIP MP, actually made some recommendations about judicial reform in his long article for The Telegraph. He recommends a Judicial Appointments Reform Act in the first month of governing. He says the Constitutional Reform Act 2005 transferred judicial appointments from the Lord Chancellor to the Judicial Appointments Committee, an independent body that lacks democratic accountability. We need to abolish the committee and restore judicial appointment powers to the Lord Chancellor accountable to Parliament. This would require a Judicial Appointments Reform Act to repeal relevant sections of the 2005 Act, disband the Judicial Appointments Committee, and reinstate the Lord Chancellor's role, effective within 6 months. You could just do this with a Great Repeal Act, get rid of the 2005 Constitutional Reform Act and Constitutional Reform and Governance Act, and make both judges and the civil service accountable to elected ministers again. He also recommends to shrink the civil service and improve efficiency, dissolving at least 8 departments, approximately 1/3 of the existing government apparatuses, via orders in council under the Ministers of the Crown Act 1975, which permits departmental dissolution and function transfers without parliamentary approval. He also recommends granting ministers the ability to appoint external experts into senior roles that civil service processes being used to obstruct, akin to practices in the US, basically making the civil service hireable and fireable by ministers, like lots of appointments are in Washington, D.C. This order in council would also amend the Civil Service Management Code, allowing ministers to dismiss permanent secretaries or directors general deemed obstructive, subject to a clear justification progress, and allow ministers to issue binding directives to officials, overriding discretionary resistance, basically forcing civil servants to either do as ministers say or get sacked. You know, like how a proper country should be run. And judicial review must be reformed so that mendacious lawsuits can't be brought by random members of the public against the government, preventing the passage and implementation of parliamentary legislation. Order 53, enacted in 1977, and now incorporated into Part 54 of the Civil Procedure Rules, CPR, governs judicial review applications. Its permissive standing rules, sufficient interest, and expansive remedies have fueled challenges to policies like the Nationality and Borders Act 2022 and universal credit rollout, with 5,000 judicial review applications annually by 2023. Reform is needed to refocus judicial review on statutory breaches rather than discretionary policy disputes. We need to introduce a Judicial Review Reform Act within the first 100 days of the administration, amending CPR Part 54 via statutory instrument to amend Order 53, CPR Part 54. These changes would restrict claimant standing, replacing the current sufficient interest test with stricter criterion. Only those personally and materially affected by the decision may apply, tightening permission requirements and limiting remedies to prevent courts from mandating policy fixes. This, alongside departure from the ECHR, would mean that mendacious lawsuits can't be brought via judicial review or Article 34. It means that Parliament can just get on with governing and conduct mass deportations. What about some other policy measures that ensure that mass deportations get done? These are things that I haven't actually seen suggested or are not robustly considered by either Reform UK or Restore Britain. And I'm just putting it out there for either party to adopt because, quite frankly, I live here. I don't care who does it, as long as you actually do it and you do it properly. Firstly, we don't have enough data on how many people are in the country and whether they're here legally or illegally. So I agree with Dr. Repeal Blairite here, who's written a policy exchange paper on the need for an emergency interim census. He notes that 3.9 million legal migrants, minimum, entered Britain between 2021 and 2024. Additionally, we don't know how many have overstayed their visas, and we don't know how many illegal migrants have entered. We only know that at least 180,000 have been recorded crossing via small boat. We don't know how many have snuck in on the back of a lorry, or other such means. In his policy exchange paper, which has a foreword written by Nadim Zahawi, who's just defected to Reform UK and is its shadow foreign secretary in waiting, therefore there's no excuse for him not to propose this policy to Zia Yusuf, Rakib notes that from April to June 2025, 53.2% of live births were to white British mothers. In 2020, 58.6% of live births were to white British mothers. In 2015, this was 62.5%. In 2010, 66.3% of live births were to white British mothers, meaning the number of births to white British mothers has dropped by 13 percentage points in the space of just 5 years. So we have no idea what the actual demographics are in our country, and it's changing at an unprecedented rate. Therefore, Rakib's policy exchange report recommends the holding of an emergency census in England based on at least 10% of a national sample, and full local censuses in 5 special study areas: Preston, Middlesbrough, Leicester, Luton and Bournemouth. The reason for this? The numbers of legal migration as well as illegal migration have been astonishing. For the year ending March 2023, total immigration to the UK amounted to an astonishing 1.47 million people, an amount exceeding the entire national populations of Cyprus and Estonia, with a record level of net migration of 944,000 registered for this period. Recent data published by the Office for National Statistics found that for the year to June 2024, the UK population increased by 755,300 people, the second largest annual numerical increase for over 75 years, with 98% of this growth being down to net international migration. From June 2021 to June 2024, based on new ONS estimates published in November 2025, the number of people who arrived in the UK in the form of long-term international migration was over 3.9 million, dwarfing the mid-2024 population estimate for the whole of Wales, just under 3.2 million. In addition to this, recent UK government data reveal that for the year ending June 2025, a total of 852,000 visas were issued for a non-visit reason, such as work, study, family, and humanitarian reasons, with the provisional estimate published by the ONS for long-term immigration during this period being 898,000, and that's not counting tourist visas, which are also the source of illegal overstays. From June 2021 to June 2024, the UK's population increased by 3.4%, over 2.3 million in the space of 3 years. According to recently published ONS population estimates for mid-2024, this increase of 2.3 million exceeds the combined population of Birmingham, Manchester, and Liverpool. The population growth has been more pronounced in England than any other home nation, increasing by 3.7% from June 2021 to June 2024. For Wales, Scotland, and Northern Ireland, the corresponding figures are 2.6%, 2.5%, and 1.2% respectively for the 3-year period. We need a national interim emergency census to know how many people are here, and whether they're here legally or illegally, and from where. It should also be noted, Rakib says, that the March 2021 England and Wales census, which happened before the Boris wave, suffered from certain shortcomings. It was held under lockdown during the COVID-19 pandemic, an exceptional period which was bound to interfere with the quality of data on work and travel patterns. The 2021 census was also poorly designed in parts, with one byproduct being the overestimation of the proportion of trans people living in England and Wales, which was eventually dropped as an official statistic. The data distortions regarding gender identity, the first time it was included as a survey item in the census, led to absurd results, such as Newham, an East London borough with a high proportion of socially conservative Muslims of Bangladeshi heritage, supposedly being home to a higher proportion of trans residents than Brighton. It's because most of them don't speak English and didn't understand the census question. The other reason we have no idea how many people are in the country is because the Home Office just doesn't keep track of it. When parliamentary questions were put to the Home Office and its civil servants by the likes of Rupert Lowe, they admitted that they don't keep data on how many people overstay their visas, or even how many illegal immigrants are in the country. Why? Because under Tony Blair in 1998, we abolished exit checks, so we don't actually check when people leave the country and whether or not they are overstaying on their visas. As Migration Watch writes, in 1994, John Major's Conservative government abolished embarkation controls, otherwise known as exit checks, for all passengers departing for EU destinations. Paper-based exit checks meant that the authorities knew when someone had left the country, and crucially, when someone had remained in the country illegally. It was a paper-based system that was not very effective and was abolished as an economic measure. In 1998, the Labour government abolished exit checks for all destinations, which meant, from 1998 to the present day, the government has no idea who is still in the country. British citizens were not affected and would not have noticed the change, but it is likely that once exit checks had been abolished, instances of visa overstaying increased. The data seems to suggest that fewer new Commonwealth citizens left the country in 1998 than 1997, which may be related to this development. We could reinstate them using the e-visa system that Harrison Pitt proposed, but the government just doesn't do it. This means we have no idea how many illegals are in the country, just vague guesses. A Thames Water report conducted in 2017, again, years before the Boris wave, estimated that as many as 1 in 13 people living in London were an illegal immigrant. They estimated 585,000 illegal immigrants currently live in London. But this is a likely underestimate. This is also before illegal migrants started crossing the Channel in the hundreds of thousands. Pew Research estimated in 2019 that between 800,000 to 1.2 million unauthorised immigrants live in the United Kingdom as of 2017. The number has changed very little since 2014. This is based on visa overstay estimates, but again, this is just guesswork. And a Civitas report in 2019, written by David Wood, Theresa May's former Director General of Immigration Enforcement of the Home Office, said that internal Home Office estimates believe that between 150,000 and 250,000 foreign nationals fail to return home when they should after their visas expire every year. So that's an additional well over 1 million visa overstayers that could have remained in the country since the Pew Research estimate of 1.2 million. So we could have within the region of 2 to 3 million illegal immigrants in the country right now. We don't know because, according to the Oxford Migration Observatory, coinciding with the Boris wave, when net migration increased to record levels from nations which are culturally distant from us, which do not practice honesty and have much higher rates of qualification fraud, the Home Office decided to just stop recording visa overstayers. As we can see in Figure 6, there is no publicly available data on visa overstayers in the UK starting March 2021, when the Boris wave began. That's also when the census was taken. So we have no idea how many people are in the country, how many legals, how many illegals, and from where. So we need to get the data on this before we can even proceed with mass deportations. We need to reinstitute exit checks, have mandatory follow-ups on all digital e-visas, and have mandatory cross-departmental data sharing and data collection. We also need to ban foreign-born individuals from claiming any benefits in the UK. Universal credit, child benefits, social housing, NHS free at the point of use, and any other taxpayer-funded benefit that they might receive. As you can see from this chart from the Daily Mail, the total universal credit bill for migrant households, that's just households led by at least one person born overseas, is 15 billion and 120 million over the past 18 months. 70% of this is given to households containing at least one unemployed foreign national. That's £10,659 million in out-of-work benefits paid to foreigners. Why are we paying for foreign nationals to just sit about and live in Britain at our expense? They shouldn't receive a penny. These are a result of Freedom of Information Access requests filed by the intrepid Rob Bates of the Centre for Migration Control. He details further on his Substack. The Department for Work and Pensions has published data showing the number of unemployed migrants receiving universal credit has increased by 55% since April 2022. Turns out, bringing in third worlders, you get the conditions, the work ethic of the third world. Who would have guessed? 771,000 unemployed migrants were in receipt of the benefit in January 2026, up from 497,000 in April 2022. For the calendar year of 2024, a total of 9,533 million was paid to households containing at least one foreign national who had passed the habitual residence test. Of this amount, 6,695 million went to households where at least one foreign national was unemployed, 70.2%. This is all without counting the NHS, social care, state-funded social housing, child benefits, and a penumbra of other taxpayer-funded benefits. Translation services for the Department of Work and Pensions so they can claim these benefits that these migrants are also taking. The bill is in the billions. And a migrant qualifies for universal credit every 43 seconds. We are just heaping up our own funeral pyre here, and myself and my children are going to have to pay for it. It should stop immediately. Nobody born abroad, even if they are the recipient of British citizenship, which should be much harder to be given out, and the terms of which should change, because new migrants should not be put on par with native Brits. They shouldn't be able to run for office, hold elective office, be employed by the civil service, or be able to vote. There are just too many conflicts of interest there. And you won't be able to do that without repealing the British Nationality Act of 1948, the Representation of the People Act, and the British Nationality Act of 1981, and the Equality Act, of course. But even if you are a recipient of a British passport, you should not be able to claim benefits. You shouldn't be able to come to my country and force me to pay for it. You either come here, subsidise your stay, and your family enables your old age, or you go and live somewhere else. As reported by The Sun on the basis of Rob Bates' research, the number of foreign nationals entitled to claim benefits has nearly doubled in the past 2 years, hitting 734,200 in the year ending September 2025. All of these people should go home. We shouldn't be paying for them to be here. They weren't wanted here. I should not be subsidising your stay in my country when there was no democratic consent for mass migration in the first place. We can just take away their benefits and they will leave of their own accord. Or, if they commit crimes, they'll be deported like any other criminal. As this paper by Whitehall Analytics on Substack points out, the benefits bill is just escalating out of control. The top 25 councils with concentrated non-British populations account for more than 50% of the housing benefit expenditure. As we've already seen by work from Juice for Pimlico Journal, upwards of half of all social housing in London is occupied either by a foreign national, a person born overseas, or a second or third generation immigrant. Meaning the majority of social housing in London is occupied by people who do not need to be here, living at my expense. After abolishing the welfare system for immigrants, we should also abolish the asylum system, which is what Restore Britain are promising to do and Reform UK have yet to promise. Because The number of asylum appeals waiting to be heard at the end of last year jumped by 104% to 69,670 by September 2025, compared to 34,234 at the same point in September 2024. New appeals submitted to the lower appeal tribunal between June and September more than trebled from 4,818 in 2024 to 16,398 in 2025. As you can see, the backlog, according to this graph, is just monumental. About 7 in 10 asylum seekers whose claims are rejected by the Home Office go on to launch legal challenges in an attempt to have the decision reversed. They shouldn't be able to do this. See the previous legal reforms that I have proposed that would stop this from happening. In December 2025, the National Audit Office revealed that as many as 4 in 10 asylum seekers are still living in Britain at a cost of billions to the taxpayer despite having had their claims rejected. Its report found the cost of supporting all people seeking asylum was disproportionately high and totaled about 4.9 billion for 2024 to 2025, driven by long delays and backlogs. That's not accounting for legal aid, and that's not accounting for the projected increase in costs as the backlog continues to grow on Labour's watch. None of these people need to be here. They can all go home. They can have their existing asylum status stripped. They can be sent to a safe third country or their country of origin if their asylum claims are illegitimate. We can save the taxpayer billions. All we have to do is have the will to repeal the laws and tell them no more, no thanks, you're going back. We should also end abused visa routes. We've already discussed the health and social care route, which for some reason Reform UK are determined to have stay in place. We should raise the minimum threshold for skilled worker visas and subject them to country bans for people that we know are not going to be net contributors, either fiscally or culturally, to our country. We should also significantly reform the partner visa route. This is something that Rupert Lowe has put a lot of emphasis on, and subject it to country bans for spouses that we know will not integrate easily into British society, are not culturally proximate, and are likely to be net fiscal costs. For example, under current immigration rules, the Migration Advisory Committee estimates that the 2022 to 23 cohort of successful applicants to the partner visa route, which consists of the partners of British citizens and settled residents, will incur a net lifetime fiscal deficit of 5.6 billion in present value terms, minus 109,000 to the taxpayer per applicant. Why are they here? They shouldn't be. The number of visas issued on the partner visa route continue to increase to the year ending September 2025. This is despite the estimation that the average partner applicant contributed only 8,600 via tax receipts in their arrival year, and that this was the second lowest contribution out of the comparator groups, with only non-working UK residents of working age contributing a lower amount. So they barely contributed more in tax than people who aren't working and sitting on benefits. We also need to stop settlement grants, because the settlement grants being given out by nationality are to culturally distant nations that nobody wanted to bring here en masse in the first place. Namely, India, Pakistan, Syria, Afghanistan, Nigeria, Iran, and China, with a few from the United States thrown in, which are just sort of the Anglo spouses of English people. And that's perfectly acceptable because the US is culturally proximate and are net contributors. Analysis of the census conducted by the Migration Observatory shows there is a positive relationship between employment and English language proficiency. Just under 70% of migrants who could speak English were employed or self-employed, compared to 50% who could not speak English well or at all. Around 15% of migrants who could speak English were economically inactive, compared to 41% of those who cannot speak English well or at all. That's 33% of Pakistani and Bangladeshis, by the way. They've never worked a day in their lives. We shouldn't be providing any taxpayer-funded translation services. We shouldn't be subsidising their social housing. We shouldn't be paying them benefits. They shouldn't be here. They should go home. But that doesn't mean we should treat all countries the same. Rupert Lowe has proposed combining an immigration red list which bans countries that we don't like from legal migration outright, with reforms to the spousal visa system that make it easier, less cumbersome, for law-abiding Brits to bring a foreign spouse from a culturally proximate country, like Western and Central Europe, or America, or Australia. Perhaps Japan, for all you weeaboos out there. Cousin marriages will be outlawed, Rupert says, so don't even try and bring your wife cousin in from Pakistan. Not happening. But if a British man wants to bring his American wife to Britain in order to build a life together, then we will encourage and enable that. I'm all for that. That's basically the only immigration that should be allowed, and it's the only way assimilation has ever happened throughout history. You marry into the tribe. Rob Bates also points out in his piece, The Pseudoscience Behind Britain's Open Borders, that Boris Johnson was deluded into creating the health and social care visa because civil servants in the Department of Health and Social Care told ministers that the numbers using the route would be small, somewhere in the region of 6,000 a year. Again, they were wrong. In 2023, 348,000 non-European migrants arrived under this route. So it's important that we drastically restrict abused routes, ban certain countries from being eligible to use these routes. We rescind visas afforded to the Boris wave, making sure that they can't just be low-wage migrants here forever. And it's also important that we remove caps on domestic doctors' training places, rather than hiring dodgy foreign doctors from overseas. It's also important that we undo one of the laws that Boris Johnson repealed, passed by Gordon Brown, which demanded that British companies advertise their jobs to British workers first, and can only advertise to foreign workers if the job plausibly cannot be filled by a British worker. It's undercutting British labour. It's a route for particularly Indian and Pakistani employers to ethno-nepotistically hire their countrymen directly from overseas. It shouldn't have been done in the first place, and Boris is a traitor for doing it. This is also the reason why we need an immigration red list, banning repeat offenders on visa overstays, banning countries we know that produce a disproportionate amount of foreign sex criminals or violent criminals, banning countries whose culture are in no way compatible with ours. And so that means, as Rupert Lowe has proposed, a sweeping bans on countries like Pakistan, Afghanistan, and Iran. I would also include India in that, because India's ministers have been clear in their attempt to disperse their excess male population across our country, to sneakily write in Indian visa routes into our trade deals, and to demographically gerrymander our democracy, to leverage Indian diasporas as client voting blocks for respective parties who have to pander to them, thereby advantaging India in foreign and trade affairs. We just shouldn't be putting up with it. It's a form of demographic warfare, they are a hostile state, and they should be punished accordingly. Here's a screenshot of my proposed red list. Pause and take notes. We should be taxing remittances, as Harrison Pitt suggested. If you look at the nations that have the largest amount of remittances taken out from the UK, India, Pakistan, Nigeria, France and Germany, China, Poland, Kenya, the Philippines, and it goes on and on. Why should our money be flowing out of our country to the pockets of India, Pakistan and Nigeria when they produce a disproportionate amount of sex criminals, violent criminals, and also they're just culturally colonising us with demographic enclaves in our major cities? It's just not wanted. It's an extractive practice. We shouldn't be propping up the failed economies of the third world, and so it should just stop. I think we should impose a 50% remittance tax on each of these countries, flat out, and then increase that tax more punitively if they refuse to take back their criminal foreign nationals and illegal migrants. We also need to stop recording this data, because this is all based on World Bank estimates, because our own government, yet again, does not record the amount of money that's sent abroad to Karim via Western Union. Poor Nick 30. The only data we have is that 27% of all foreign-born individuals sent remittances abroad in 2022. This does not count second-generation migrants who are still sending money back to their ancestors in their home country. That's 13% of EU citizens and 32% of non-EU citizens. Notice the disparity there, given non-EU citizens are disproportionately more likely to claim universal credit and other forms of benefits. So it's our tax money being sent as remittances back to the third world. No thanks. That's 40% of sub-Saharan Africans, 37% of Middle East, North African and Central Asians, 33% of Southeast Asians, Pakistanis, Bangladeshis, Sri Lankans and Indians, and 31% of South Asians. And then we come on to indefinite leave to remain. This is something that Reform have promised to repeal retroactively, but as Charlie Cole points out in this excellent piece for The Critic, that won't get the Boris wave to leave, because the first part of the Boris wave that arrived in 2021 are now going to be eligible for indefinite leave to remain this year, and some of those will apply for citizenship, and some of those will be granted it, meaning the Boris wave are here to stay unless Reform are willing to repeal citizenship grants and send people home. This is a problem because they've said they're not willing to do that. As Charlie notes, beneath that horrific net migration graph, the Boris wave is nearing its time to qualify for indefinite leave to remain, a status which, if acquired, enables them to live and work in the UK indefinitely, and access a raft of state benefits from social housing, universal credit, and personal independence payments, PIP. The Centre for Policy Studies' Carl Williams released a report estimating the Boris wave, if allowed to settle under current ILR rules, would have a lifetime net fiscal cost of $234 billion. The figure was based on Office for Budget Responsibility data on migrant earnings. This has since been withdrawn, but if anything, it's likely to be an underestimate because the OBR assumes most migrants arrived aged 25 and bring no dependents, something we know to be categorically false. Also, the OBR underestimated net migration by a factor of 2 to 3 every year. So it's likely going to be much, much worse. Fast forward to 2025, and Reform UK has pledged to abolish ILR entirely, including rescinding it retrospectively to prevent the Boris wave from settling. But there's one problem with Reform's policy, Charlie notes. Under current rules, most migrants qualify for indefinite leave to remain after being present in the UK for 5 years. The Boris wave started arriving on the 1st of January 2021, meaning the first cohort of the Boris wave will begin to qualify for ILR from the 1st of January 2026. So it's already happening. Once a migrant has ILR, they can apply for British citizenship after a further 12 months, meaning the earliest cohorts of the Boris wave could start qualifying for British citizenship from the 1st of January 2027. If significant numbers of the Boris wave obtain ILR and subsequently citizenship, both of which have 90 to 95% grant rates, then Reform's plan will be meaningless by the time the next election rolls around, which could be as late as the 15th of August 2029, by which time most of the Boris wave could already have British citizenship and would be immune from any revocation of ILR, even if rescinded retrospectively. Already we see record numbers of British citizenship grants being issued by the Home Office. In 2024, the Home Office issued 269,806 grants, the highest since records began in 1962. And by the way, all those Afghans that Robert Jenrick let into the country under the Ministry of Justice leak, and their 22 family and clan members allowed in per an ECHR ruling, they automatically got ILR upon arrival. So they don't even have to wait 5 years to apply for citizenship. And if Reform are unwilling to remove citizenship grants, as Nigel Farage has said, we're stuck with all those Afghans forever too. And Nigel Farage confirmed at a press conference that no, if you've been granted UK citizenship, you have been granted UK citizenship. To be absolutely clear, there should be no confusion over that. You know, we would not retrospectively change that because you become a legal citizen of this country. We would never suggest otherwise. So Nigel Farage is against repealing citizenship for anyone. This is a disaster because the Boris wave will not be going home under a Reform government as current policies stand. Presently, Shabana Mahmood is proposing to extend the indefinite leave to remain timeline to 10 years, though currently civil servants are advising her not to do that to the Boris wave. So the Boris wave could still get citizenship by the 2029 general election. And so Charlie writes, if indefinite leave to remain isn't increased to 10 years, and this change doesn't apply to those who are already in the UK but are yet to obtain ILR, then much of the Boris wave could be citizens by the time of the next election and would be immune from any rescinding of ILR. In this scenario, Reform would either have to accept the Boris wave is here to stay, or be willing to cross the Rubicon and revoke previously issued citizenship grants. So it's kind of ironic then, as the community note points out, that Nigel Farage says nobody voted for the Boris wave. Because not only did sitting members of Reform's shadow cabinet vote for the immigration measures which brought the Boris wave into Britain, and the pending cabinet minister Nazim Zahawi, but Nigel Farage is also refusing to deport the Boris wave or to strip them of their citizenship, meaning it is Reform policy that the Boris wave remains here forever unless things change. And so this is why Restore Britain must pledge to repeal any citizenship grants given to the Boris wave. The public support this already, by the way, including a large number of Reform UK's own voters. 45% of Britons believe that large numbers of legal migrants must be sent home too. It's not just a matter of illegal migration, they just don't want the Boris wave here. And that's when they're underestimating net migration by a factor of 10 and believing that the vast majority of migrants they see in their high streets are illegals rather than legals. They don't care about the legal procedures that have brought these people here and allow them to stay, they just want them gone. And the party promising to do that will win the battle on who is more credible to deliver mass deportations. As David Shipley points out in the Spectator article, the Rubicon for denaturalization has already been crossed. After El Fattah, the Egyptian terror sympathizer, was brought here by Keir Starmer, but with the agitation by both James Cleverly and Alicia Kearns, former Conservative ministers, most of the public are now in favour of just removing his British citizenship and sending him back to Egypt. A More in Common poll found at the week that this article was published whether it was right or wrong for the government to welcome El Fattah to the UK, and only 12% of people thought it was the right decision, 81% of Reform voters and 75% of Tories thought Starmer made the wrong choice, What's perhaps more surprising is only 11% of Lib Dems and 23% of Greens thought that Keir Starmer got it right on El Fattah, and only 24% of Labour supporters felt welcoming the Egyptian to Britain was right. The pollster then asked whether British citizenship is a privilege which the government should be able to revoke in particular circumstances, or a right which should not be revocable. By a margin of 2 to 1, the British public think citizenship is a privilege which should be revocable by politicians in certain circumstances. A majority of supporters of every party share that view. 79% of Tories, 76% of Reform, surprising that's lower, 64% of Lib Dems, 57% of Labour, and even 54% of Green Party voters are in favour of revoking citizenships. Denaturalisation is the majority position among the British public, so Nigel Farage is yet again to the left of the British public on denaturalisation and deportation. This is easy ground for Restore Britain to take away from Reform UK. It's ground that the public wants, and it's ground that would win them votes. And it's not like it requires drastic legal reform to do so. If you pass the previous mentioned legal reforms, to the judicial review process, to leaving the ECHR, to amending the 1951 UN Refugee Convention, to removing the Equality Act, the Constitutional Reform Act, and the Constitutional Reform and Governance Act, if you replace the civil service, all after winning an outright majority at the next election, then it's actually easy to use the existing executive powers enjoyed by the Home Secretary to strip people of their citizenship and deport them elsewhere. This is a report from the Runnymede Trust, a left-wing NGO that introduced the concept of Islamophobia to Britain in 1997. And they have listed not only all the powers enjoyed by the Home Secretary that allow the Home Secretary to strip people of their citizenship, but they helpfully number the prospective number of people who might be eligible for their citizenship being stripped and sent back to their homelands. Pages 8 and 9 of the report note that the UK has signed and ratified both the 1954 Convention relating to the status of stateless persons and the 1961 Convention on the Reduction of Statelessness Treaties that place obligations on governments to protect the right to a nationality and to prevent statelessness. However, the UK maintains several reservations to these treaties, and neither convention has been fully incorporated into domestic law. We should maintain that status, and if it presents a legal challenge to denaturalisation, we should just leave them outright. Section 40 of the British Nationality Act 1981 provided for removal of citizenship if it had been obtained by fraud. Grounds for deprivation were dependent on the Secretary of State establishing the person's ongoing citizenship was not conducive to the public good. In 2002, the Nationality, Immigration and Asylum Act extended the deprivation powers to those born British as well as naturalised and registered citizens, provided they had another citizenship. It also replaced the list of specific grounds set out above with a catch-all criterion of doing anything prejudicial to the vital interests of the UK. The test no longer required an individual to have committed a defined set of acts. In addition to the general test, the broad catch-all sufficed to remove citizenship. The 2006 Immigration and Asylum Act further lowered the legal bar to being stripped of citizenship, reducing the threshold for deprivation of citizenship from doing anything prejudicial to the vital interests of the UK to being merely conducive to the public good, a broader and less precise test. The 2014 Immigration Act, for the first time, allowed citizenship to be removed from naturalised Britons with no other citizenship who had done anything prejudicial to the vital interests of the UK, provided the Home Secretary had reasonable grounds for believing that the person is able, under the law of a country or territory outside the United Kingdom, to become a national of such a country or territory. So, hypothetical eligibility for foreign nationality allows you to be stripped of British citizenship, even if you are a second or third generation British-born immigrant. In 2022, Section 10 of the Nationality and Borders Act allowed for citizenship to be revoked without those affected being notified, so you can unilaterally do it without advance warning. In 2025, the Deprivation of Citizenship Orders Effect during Repeal Act further expanded these powers, preventing people stripped of their British citizenship from exercising their rights as British citizens, even after the courts had ruled that the Home Secretary's actions were unlawful. A person successfully challenging their deprivation now does not get their citizenship back until all appeals by the government have been exhausted, a process which can and often does take many years. So the government can just keep denying the appeals process under existing law, which will be way easier if all of the aforementioned legal and treaty revisions are made. As the report points out, citizenship deprivation decisions are made by the Home Secretary, making this a concentrated executive power. There is no requirement that the person deprived be convicted of any offence prior to the deprivation. So, if you want mass deportations done, if you want to reverse demographic change, you need to elect a party that puts a Home Secretary in power that is willing to do this. That is not Reform UK. And one of the reasons that it won't be Reform UK is because Zia Yusuf himself is a Sri Lankan Muslim. and he doesn't want to be shunned at his iftar dinners, or by his friendship groups in the international business class. And this is a problem because those eligible for citizenship share his ethnic background and his religion. As the Running Me Trust points out, 9 million people risk being stripped of their British citizenship under existing laws. That's upwards of 60% of ethnically Asian and black people living in Britain. The largest groups for people that are eligible for deprivation include Indians, Pakistanis, Romanians, and Jamaicans. They also include the Irish, but I don't see us stripping citizenship of the Irish anytime soon because they're a native British people. Furthermore, if we're interested in deporting foreign criminals, does that just mean criminal foreign nationals or people of foreign extraction that have committed crimes? Because if the latter, which I personally advocate for, but which currently no political party advocates for, if the latter, we can remove millions of people with a criminal record that never need to be in our country in the first place. And this is actually acknowledged by a 2019 report that David Lammy wrote the foreword for. On page 8, it says that 1 in 5 black, Asian, and minority ethnic people have a criminal record. In 2019, that was 1.5 million people. They round it up to 1.6. So that means that at least 1.6 million foreign origin criminals are in Britain. Why? They don't need to be here. They can be stripped of their citizenship and sent home. I think that would be sensible. We do not need any foreign criminals in our country at all, and we can just remove their citizenships and send them back. All that we lack is the political will, the courage, and currently the legal mechanisms to do so, but judging by existing repeals that I've already suggested, that's simple as a Great Repeal Act on day one. The way we can do this is actually outlined by Douglas Carswell in his Milestones essay for The Telegraph. He says, the British Nationality Act 1981 permits citizenship revocation when conducive to the public good, as we've already covered. This has been exercised 104 times in 2022, primarily for terrorism-related cases. The most famous example, of course, is ISIS bride Shamima Begum. There needs to be a massive increase in the use of this power to revoke citizenship from those supportive of political Islam. We must amend the 1981 Act to explicitly allow citizenship revocation for individuals who advocate replacing British law with Sharia or other non-democratic systems, express support for prescribed terrorist organisations, or promote violence against apostates, dissenters, free speech advocates, or minorities. I don't know why minorities is in there. It should be anyone who expresses ethnocidal rhetoric, anti-white racism, or support for Sharia law should have their citizenship stripped and returned to a country full of people who think in the same deranged way that they do. Douglas suggested this should be called Shamima's Law. I like the framing. Remember, all that we lack is the political will to do it. Finally, let's learn some lessons from the Trump administration. Firstly, that any deportation effort will not succeed if you're not honest with the public. We often hear about these millions of self-deportations that have been successfully conducted in the first year of the Trump administration. Well, as the Center for Migration Studies points out, this is based on erroneous readings of census data. They say that in late September 2025, the Department of Homeland Security jubilantly announced that 2 million illegal aliens have been removed or self-deported since January 20th of 2025. In mid-December, it went on to brag that it was shattering records with a total of 2.5 million illegal aliens having left thanks to President Trump. But this DHS allegation would amount to 200,000 people per month having voluntarily left the country. And this exodus is not likely to have gone unobserved. This DHS announcement relies on a chart from a blog post posted 2 days prior by a think tank called the Center for Immigration Studies, and they explain their analysis is derived from the current population survey and document their interpretation of the data. This is fraught with the same errors as extrapolating data from the UK census because of low response rates from immigrants, especially at a time of hostility towards illegal immigration, so they don't want to out themselves as illegal migrants because they might be detected and detained and deported by ICE, as well as low levels of English language speaking, meaning that those immigrants are unlikely to respond to the survey. It's riddled with selection biases that make the data impossible to extrapolate. The main shortcoming of the CIS analysis of immigrant out-migration based on CPS tabulations appear to stem mostly from worried immigrants not responding and consequently biased survey findings, not from a massive exodus. So there haven't been millions of self-deportations. Now, there have been some self-deportations, but not to the scale promised. And if you overpromise and underdeliver, you're going to disillusion your own supporters and weaken public consent for mass deportations. So it's very important that you have a continuous, honest, alternative media ecosystem that is fed reliable data by government departments, that keeps the public informed on just how the mass deportation efforts of both voluntary returns and enforced deportations are going. The same thing happened in Sweden when they were cleaning up taxpayer rolls and it was mistakenly reported as mass net emigration. It just isn't the case. We need to be truthful about the scale of self-deportations and enforced returns, otherwise the public will lose confidence in the system. And legal migration restrictions will be opposed by business interests. There was this article in the Wall Street Journal just a couple of days ago saying America's strength rests on sustained capital investment, but also on a growing supply of labor. More workers means more production, consumers and demand. The Trump administration's mass deportations threaten to break that virtuous cycle. You will get the business community and their proxies in the press coming out and signaling against you if you threaten their GDP growth at all costs model by refusing to continually grow the population and drive down the cost of labor for native workers. They want their cheap labor, they want their GDP growth, they want to continue living off the mortgaged futures of the next generation, and if you threaten to oppose that model, they will move against you like they did against Liz Truss. That's why leaving the OBR and the Independent Bank of England in place is so dangerous. The bond market will move to scupper your plans to conduct mass deportations if you allow them. That's why you need to get the business community on side before winning the election. That's why you need to make the case clear to the public. The mass deportations will save them money. And that's why you need to wholesale reform the civil service, the financial sector, and the state. It all needs to be accountable to ministers. And you need to have people in the media making the case for you. You shouldn't, as Reform has been doing, piss off your base to the extent where they will no longer do your marketing for you and will instead coalesce around a rival political party also promising to do mass deportations in more detail. Overall, I am unconvinced by Reform's offerings on mass deportations, so it's frustrating that they are currently poised to become the next party of government. I think they're not going to deliver because they're either not sincere in what they're promising or are ill-equipped to deal with resistance from the judiciary, the civil service, the business community, and the media. They have too many moneyed interests pulling their strings as it is, so when they get into government, it's going to be even worse. I trust Rupert Lowe. I trust Restore Britain. And I think that if you're in the business of being a single-issue voter on demographics and mass deportations, then it's better to lend your vote to Restore Britain than it is Reform UK.